Who are the heirs of a deceased person? Heirs are the individuals named in the deceased's will, or the surviving spouse if the notarized marriage contract provides for this. Otherwise, if the deceased has neither a will nor a marriage contract containing a testamentary clause, the law determines who the heirs are. This is known as legal devolution. The law provides for 3 orders of heirs. For starters, descendants have priority over other family members. Descendants are the children, grandchildren, great-grandchildren, and so on. They represent the first order, which means they have priority. The second order consists of the deceased's parents, siblings, and nieces and nephews. People in the second order can inherit only if there is nobody in the first order, in other words, if there are no descendants. The remaining family members belong to the third order. Grandparents, aunts and uncles, cousins and grandnieces and grandnephews can inherit if there is no one in the previous 2 orders. What about the spouse? The spouse is in both the first and second orders. They can therefore inherit along with the deceased's descendants. If the deceased has no descendants, the spouse can inherit along with parents, siblings, and nephews and nieces. For the purposes of legal devolution, the notion of surviving spouse notably includes the married or civil union spouse of the deceased. Marriage and civil union are civil states that are clearly identified by a government document issued by the Directeur de l'État civil. This blue document resembles a birth certificate. As of June 30th, 2025, the notion of surviving spouse will also include the person in parental union with the deceased. A parental union is established when de facto spouses become the father and mother of the same child after June 29, 2025. Therefore, parental union does not apply to a de facto spouse whose children were born before that date, and does not apply to a de facto spouse who has no children. Divorced persons, de facto spouses without children, or de facto spouses with children before June 30th, 2025 are not considered spouses for the purposes of legal devolution. They cannot be heirs under the law. To inherit, they must be named in a will. Here are the questions to ask yourself to determine who will inherit according to the law. First question: did the deceased have a spouse? Second question: did the deceased have children? Children may or may not be common to the couple. If the deceased was married and had 1 or more children, the estate goes to them. Third question: did 1 or more children pass away? In this case, the share will go to the children of the deceased child, so to the grandchildren of the deceased. It then goes to their children in the event of their death, as long as there are descendants. How do all these rules fit together? If the deceased has a living spouse and descendants, they will share the inheritance. If the deceased has no living spouse, everything goes to the descendants. And as long as there are descendants, it doesn't go to the second order, which means other family members won't inherit under the law. We move on to the second order if the deceased has no children or if all his descendants are deceased. Let's not forget that the second order is made up of the descendants' parents, siblings, nephews, and nieces. If the deceased has a spouse, the spouse must share the inheritance with the second order. Once in the second order, there are also questions to ask yourself. First question: is one of the deceased's parents still alive? If they are still alive, they will receive a third of the inheritance. If one of the parents of the deceased is dead, the other parent inherits their part of the estate. If both parents are deceased, the siblings can inherit. Second question: have any of the siblings passed away? If so, their share will go to the children. This is the only way nephews or nieces can inherit under legal devolution. If the deceased had a spouse but no parents, siblings, and nieces and nephews, then the spouse inherits everything. On the contrary, if the deceased has no spouse, or if the spouse is already deceased, the deceased's parents and siblings inherit. If the deceased has no spouse, children, parents, siblings, or nieces and nephews, we move on to the third order. The third order is made up of grandnephews and grandnieces, grandparents, uncles, and aunts, as well as cousins. They may therefore be entitled to a share. A complete analysis of the family situation is required to identify each person's share. The rules of legal devolution may seem complex, but our team will help you untangle them and, above all, help you to ask the right questions. Do you have questions or doubts about your eligibility? Contact us at tabac@proaxio.ca or by phone at 1-888-880-1844.